Thank you for your patience. We'll get started. Chairman Hamilton has House Bill 126. Good morning.
Thank you, Mr. Chairman. Members of the committee, I bring to you committee sub for House Bill 126. The subcommittee did a little wordsmithing, and we appreciate that, helping perfecting this bill. All it really does is address a situation where currently park rangers are not covered under state statutes while conducting their official duties. There is a term called conservation ranger, but it has been deemed that that does not fit, and so park ranger covers that. And that's all we're doing is adding park ranger to that particular code section. I'd be happy to answer any questions or give you any information. Would ask for your favorable consideration of this measure. By the way, it was brought to me by the Corps of Engineers and the Hall County Solicitor because of the current situation over there where they've had to try to seek federal charges because they're convinced that state charges would not they would not be able to have a felony charge under state law.
Questions from the committee? Seeing none, has anyone signed up to speak? No one that I can see. Is anyone here to speak for or against House Bill 126? Seeing none, Council, have you had the opportunity to take a look at it? Do you see any issues? Okay. With that in mind, what's the pleasure of the committee? Move to pass by Ms. Randall. Is there a second? Second by Ms. Ballinger. Are there any amendments? Seeing none. Any further discussion? Seeing none. All in favor of the gentlelady's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Chairman Hamilton.
Thank you, Mr. Chairman and members of the committee. Thank you.
And I encourage you just to make sure you go up to Chairman Meadows and fill out the form so that you can be on the blue sheet Tuesday morning.
You can bet that's almost already done.
Okay. Thank you. Anticipatory. I understand.
Well, it was said that one reason it got through subcommittee so quickly is that you were not there that
day. now that he's got his motion, he's out the door, right? You know, he's got 1 foot out the door. There you go. That's going to come back to him. Just saying. All right, let's begin consideration of House Bill 349. This is a hearing only. This is the second phase of the governor's criminal justice reform initiative. This comes off the heels of House Bill 1176, which passed last session, and it is our continuing attempt, the governor's continuing attempt, in partnership with the legislature, to be smarter on crime. We've heard the expression tough on crime, soft on crime. Well, this is smarter on crime. We're making some cutting edge decisions that will bring some more common sense to our sentencing laws, and also free up our prison beds, as Commissioner Owens would say, those hard beds that are inside the wire, for those who are truly a threat to public safety. We have 3 core missions: public health, public safety, public education. This is obviously hitting on public safety, and the mechanism or the initiative of the governor, and really in light of his vision on this issue, is pushing us toward a smarter on crime approach, where again we reserve those hard beds in our correction system for those who we simply need to keep away from society, and taking those individuals who do not represent a threat, nonviolent offenders, and where possible, under the rubric of our accountability courts, including drug courts, are potentially can be filtered back into society with rehabilitation. Potentially not. That is a case-by-case basis. And those decisions are made by judges. Why? Because that's why we have judges, like our Judge of the Week, Lawton Stevens. Thank you for being here. But that's the vision. That's the overall view that I think the governor clearly has taken. The previous year, this is the next step in that broader conversation of really remaking our criminal justice system and really modernizing it according to today's conditions. So with that, what I thought we would do is there are various sections of the bill. What I think I'd want to do first, there are two sections, one that has to do with the response, or to bring our code and really the response to the recent Supreme Court decision in what's known as the Wilson case. And there's also a section having to do with evidentiary rules as it relates to child molestation issues. Those are two issues that are of importance to all of us, but have come to us proactively through the DA's Association and the Prosecuting Attorneys Council. What I thought I would do and would ask is if a representative from the DA's Association and or PAC would want to come up to speak to those two issues. I think the Wilson decision is pretty self-explanatory. It's so simple that even I can explain it. But then I think it would be helpful if our prosecutors could get into the details of the evidentiary issue as it relates to child molestation. Just to try to summarize the Wilson issue, the Supreme Court recently ruled that given the use of the word knowingly in our drug trafficking statutes, they ruled that because of the way the statute is constructed, that the state had to prove that an individual knew the weight of what they were trafficking. That is, if you're going to go ahead and make a drug trafficking conviction stick, you had to prove that they knew that they had exactly 35.8 pounds of whatever it may be, no more, no less. And obviously that's a fiction, but if that's the way the court construed our statute and what it meant, then we have to go ahead and take a look at it and do what we do so often, which is a statutory fix. Let me ask you to go ahead and expand on that to the extent that you want to or need to, or if I've completely misstated that, that's fine too. Correct me, and then if you would get into the evidentiary issue on the child molestation piece. And Mr. McDade from the DA's Association, Mr. Speyhaus of the Prosecuting Attorneys Council, welcome and good morning.
Good morning.
Mr. Chairman, I'll address the Wilson issue for you, and one of the reasons that you've done an excellent job of actually describing what the court ruled and how the proposal's been to fix it is to remove the element of knowingly there. Keep in mind that this does not remove the necessary element of intent in any criminal case that we have to prosecute. One of the reasons that it is brought all the way down, and what I'm talking about is Section 4 of the bill, the reason it is being struck throughout the bill and not just at the beginning of the bill is because of the weight-based sentencing now. So the concern is that Wilson, which then applied to the trafficking statute, the concept of knowingly and how that would apply to the possession of drugs now runs all the way down the trafficking statute as was amended under the Criminal Justice Reform Bill of last year, because weight is now an element in determining sentence. So that's the reason it struck all the way through, and that quite simply was the decision of the court, the response that basically the court told us to that we would have to fix.
Any questions from members of the committee on that particular section, what we'll call the Wilson fix as it relates to weight-based prosecution and then the use of the word knowingly? Any questions, members of the committee? Mr. Strickland. Mr. Hightower, I'm sorry.
Sorry. When I'm looking at this at line 90 and 91, I believe that's where you're talking about. Is that correct?
Yes, sir. That's where it begins.
Okay. The first knowingly, I understand why we would strike knowingly in line 91, because that goes to possession of the weight. Why are we striking knowingly in line 90? Because if and I haven't read the Wilson case, but if we're strictly going at them anyone having to prove that they knowingly had a certain amount of weight, it seems like the knowingly in line 90 could still remain as long as we change the language a little bit and struck knowingly in 91.
The concern is under a strict construction analysis of these statutes that knowingly, the first knowingly, could still modify the rest of the sentence.
Would or not take care of that? Any person who knowingly sells, manufactures, delivers, or brings into this state and then change the sentence to possess?
I think the problem could be then if the elements of sell, manufacture, and deliver as opposed to just possession were present, then you would still have the same problem.
The language that's currently in Section 4 of the bill is reflective of the same changes, the same language that's in the possession statute. We don't have knowingly in there.
Okay. I was reading it in this vacuum strictly. So.
Yes, sir. It is difficult to read it in a vacuum.
Okay.
Any further questions on that particular provision from members of the committee? Seeing none, and just to make sure it's clear to members of the committee, this is not a one-time shot. This is a hearing only. If there are any issues that come up over your review over the weekend or early next week, obviously, please bring them to the attention of the chair, and that's what this process is all about. With that, let me ask you to go ahead and get into the suggested change on, well, actually on the appeal issue, which I may have neglected to mention before, the appeal issue, and also on the evidentiary issue as relates to child molestation. Whatever works. Yeah.
Are we leaving Section 4 or are we still in Section 4? What's your suggestion?
I think we're about to leave Section 4 unless you've got an additional question.
I don't know that I do. I just text on line 6, correction on page 6 and 7, where that's all talks about the discretion for departing from mandatory minimums. Is that something that we're going to address later?
We are. I'm sorry. I didn't mean to envelop that into the same discussion point. That is going to be a separate point of discussion later on in the hearing, but just for purposes of the fix on the Wilson case. But yeah, absolutely, we're going to be getting into that.
Okay, I'll go ahead and cover the appellate section since it's first in the bill.
Okay.
Like I said, Mr. McDade is doing good to communicate in his current condition, so he's stuck with us all week despite how he's felt. What this does, what Section 1 does, is brings into line the state's right to bring an appeal of a decision of a court prior to trial of exclusion of evidence. Here's what's happened. It's been an issue in the past, but at least prior to the new evidence code, we had a fairly well-established body of law about what our evidence rules mean. The problem now, after HB 24 last year and the final provisions of that have just gone into effect, the state is often in a position now to have rulings about the admissibility of evidence that we can't get in front of an appellate court. What would happen, and I'll use for an example the admission of prior acts, or what was formerly called similar transactions. How that typically takes place in court is the state files a notice that they intend to introduce that. There's certain requirements of that notice that's provided to the defendant. The court would generally schedule a hearing prior to trial. Sometimes, and it depends on the court how far out that is. Obviously, if this passes, that might be changed so that the courts have plenty of notice whether or not the state intends to take a case up on appeal. But what would happen is a court would enter an order saying, in this case, no, that this similar transaction evidence is not going to be admissible. The case would go to trial, and of course, regardless of how it turns out, the state would not have an opportunity to ask the appellate court to consider that, particularly if there's an acquittal or a conviction of a lesser offense or what have you. There's just this instance can continue to reoccur where the state believes that the court is incorrectly applying the new law, and there's never any way to get a review of that. That's what this does, is it allows the state, upon notice to the court and a certification that the appeal is taken not for purposes of delay, and that the evidence is a substantial proof of a material fact in the proceeding. So this is not just a low standard that we can just arbitrarily do this. The court would have the prosecutor would have to certify to the court that that is the case, and then we would be allowed to take that case up on appeal and have that consideration ahead of time. The other provision is starts on page 3, and it's line 64 through 70. And what that is it is again an equaling of the instance when if a defendant is allowed to take an interlocutory appeal, i.e. An evidentiary issue up to an appellate court before a case is tried, that the state then has the right to cross appeal on any matter that was ruled on by the court ahead of time. Again, puts us in the same situation as the defendant. If the defendant decides to appeal an issue, then the state has the right to appeal any other issue that has been ruled on prior to trial.
Questions from members of the committee on the appeal provisions as described by Mr. Spejas on pages 2 and 3. Seeing none, I think it'd be good to, since you're up here, to go ahead and move into the evidentiary issue as it relates to the child molestation prosecution.
Thank you, Mr. Chairman.
Let's make sure we're committee members know where that is in the bill.
It starts at line 544.
Line 544. Page 16.
We'll see. Mr. Chairman, I'm going to try to speak as best as I can. I apologize.
Take your time.
There is a body of law in Georgia that is generically referred to as the child hearsay statutes that offers certain protections to child victims who are witnesses when they have to testify in cases. Under the child hearsay statute, for many years the law has been that a statement made by a child who was a victim, and then later the statute was modified to include or who was present and witnessed a child being victimized, that those outcries and those statements made by that child to a third party could be introduced into evidence with certain procedural safeguards in place through the voice of a third person who heard the child make the outcry or make the statements. The child had to still be available for cross-examination, and the court had to make certain findings. There was a Supreme Court decision several years ago, many years ago, that addressed that statute and said that the protections that were being afforded to children were okay so long as it was just the child that was the victim that had been particularly harmed by the crime, and said that the language in the statute that said, and a child who also witnesses it, that those statements could also be given that same protection. That language was struck down by a Supreme Court decision years ago. And when the evidence code was rewritten last year, because that particular phrase had been declared unconstitutional by the Supreme Court, in the evidence code rewrite, that sentence was deleted. What happened since the evidence code rewrite was the Georgia Supreme Court, in a decision that was rendered June of 2012, it's called Bunn versus the State. Justice Namias, in a decision, very carefully traced the history of that statute and the reasons why it's important that protection extend to that other child. A child who also witnesses the abuse is entitled to just as much of the state's protection and the comfort that the court system can give it with certain restrictions in place. The Bunn decision struck down the previous decision that had excluded that sentence in the statute. Bunn restored it and invited the legislature to restore it as part of the legislative process. And that's what this does. It puts the law back to where it had been pursuant to the Supreme Court's current pronouncement on this issue. There was another decision that came out a few months prior to that called Hatley, H-A-T-L-E-Y, that was decided in February of 2012. And Hatley reiterated the Supreme Court's desire to make certain there is proper notice to the defendant, proper notice to the defense counsel, and to the court that the state is going to offer one of these statements through a third party to give the defense the time to prepare to cross-examine or to decide how they're going to approach that. And the language in this bill under Section 11 implements those procedural safeguards that the Supreme Court asked for in Hatley and substantively adds back the language that the Supreme Court in Bunn said should be in the statute.
So to summarize, what that language proposes to do is to bring the statutes in alignment with the Bunn decision, which essentially overturned the court's previous precedent on the admissibility of testimony of a child who may not have been the direct physical victim but was in the room at the time, and to use that individual child's testimony as evidence against the accused.
Correct.
With the safeguard, with the usual safeguards of allowing for cross-examination under certain conditions
Yes, sir.
as we do in those special situations.
Yes, sir. Oftentimes, children are abused in a setting where there may be more than one child present in the room. In child molestation cases, in a number of cases I've personally prosecuted, siblings may be in the same bed being molested by the perpetrator, and the child that's there while it's occurring is being just as traumatized witnessing the abuse as the child being traumatized physically. And so the protections afforded by the Supreme Court say that there's no reason for the state to separate the protections available to either child from the trauma they're experiencing and then having to come to court and testify about it.
Okay. Questions from members of the committee on that provision? Mr. Pack.
Mr. District Attorney, that I walked in kind of late, but question about, it looks like you're trying to put in there as one of the hearsay exceptions. Question, you mentioned the state Supreme Court, but is this consistent with the latest ruling by the Supreme Court, the U.S. Supreme Court, on the Confrontation Clause? Because I know in the child abuse and rape cases, there's a careful balance that they balanced, and then recently the Sixth Amendment Confrontation Clause jurisprudence seemed to be restricting the hearsay exceptions to those that are traditionally found to be, I guess, routed in constitutional law. I'm wondering if the exception that we're using here has been found by the U.S. Supreme Court as one of those traditional testimonial exceptions to the Confrontation Clause.
What I can tell you is that the Supreme Court of Georgia's decisions in Hatley were responsive to the federal constitutional analysis, and this statute incorporates the Hatley concerns that were being addressed as it came out of the U.S. Supreme Court. There are requirements that I think procedurally protect what this legislation is trying to do, embodied in this legislation, from federal scrutiny or from, I think it's in compliance with the federal statutes.
I see no further questions. Thank you very much.
We'll be available for any other questions.
Thank you. Let me call Judge Michael Boggs from the Georgia Court of Appeals. Judge Boggs served, maybe still serves, as chair of the Governor's Special Council on Criminal Justice Reform. The council was formed, just to refresh everyone's recollection, in 2011 as a result of legislation passed by Representative Neal, Chairman Neal. That council made several recommendations late in 2011 that were incorporated, most of which were incorporated into House Bill 1176 that was passed and enacted into law last year in 2012. The council continued its work during the balance of 2012 and issued a set of recommendations late last year, and House Bill 349 again represents some of those recommendations. There were two sets of recommendations. One was on the juvenile side, which involves the House Bill 242 that's being shepherded by Chairman Willard. And there was another set of recommendations that had to do on the adult side that are now housed in House Bill 349 that we have before us today. There are several recommendations as it relates to the adult piece. One major recommendation that touches two areas, one having to do with serious violent felonies and other having to do with drug trafficking, have to do with providing increased judicial discretion as it relates to sentencing in those areas under very narrow, limited circumstances. Those circumstances are enunciated in the bill, both as it relates to serious violent felonies and also to drug trafficking. Beginning on line 193, if I've got that right.
Yeah,
and what the under those very narrow, limited circumstances, which the defendant in that situation under drug trafficking, the defendant would have to go ahead and meet all of those conditions. I want to repeat, all of those conditions in order to have the opportunity, just the opportunity, to have for the judge to consider a reduction in that sentence, which the judge could or could not do in his or her discretion. And then in that situation, what would occur is the judge would have the opportunity, if he or she saw fit, to reduce that sentence a certain percentage. And what we've done in this bill is set out, and it's a fairly long laundry list, of course, but what it comes down to is if the defendant met all of those conditions, and then if the judge decided to go in that a downward departure in sentence would be appropriate, the judge could depart as much as 50%. And so what we've done in the bill, and it looks fairly busy in terms of all the sections and subsections and sentencing ranges and fines, but essentially what it does is we've taken the range. For instance, if a minimum mandatory is 10 years, if the defendant were to go ahead and meet all of the conditions, and if the judge were to go ahead and decide, yes, this is an appropriate time for the exercise of discretion, the judge, we would provide a range that would be half of that minimum mandatory up to the minimum mandatory. And so the judge would have the opportunity, if it were appropriate, if the defendant were to meet all of those conditions. I'm going to keep on saying that because that is an extremely important piece of the legislation. And I'll get to that in a second. It provides the judge that window. It isn't, so, it's a very healthy window because there might be a situation where that individual defendant may warrant 5 years. And it's a 5-year minimum mandatory. So if they were going to go and get that reduction in sentence, they would serve every day of that sentence, whatever it would be. The judge might think, yes, a 50% reduction is appropriate. The judge might say, no, the 10-year minimum mandatory is appropriate. Or the judge would have the discretion of going anywhere in between. And that, of course, is a case-by-case analysis. Every case is different, every defendant is different, and the judges have to go ahead and, as opposed to having their hands tied, the judges need to have the opportunity to judge these cases, judge these individuals on a case-by-case individual basis. I said it before, I'll say it again. This is exactly why we have judges. If they don't have discretion to make these decisions, we could go ahead and put a computer up on the bench and just have a computer software program. But it's not that cut and dry. It's not that simple. And these are human beings that we're talking about. And these are very different factual situations. That's why we have judges in these positions to make these tough calls, and they are very tough calls. One thing that I wanted to stress, and then I want to get the perspective of Judge Boggs as chairman of the council. One thing I wanted to stress is that, and I said this in the last day or so in a public comment, that we're not plowing new ground here. This is something that's been in place in the federal system for quite a while. This does not mirror the federal system in terms of the conditions that a defendant must meet in total, but it is very, very similar. So I just want to make sure it's clear that this is not the state of Georgia going out on some limb. What we're doing really is getting ourselves in alignment, I think, to a very large degree with the success that I think we've seen in the federal system in terms of allowing judges to use their discretion in very limited circumstances. I've also been provided with data in the last week or two that came from the Corrections Department, and thank you, Commissioner Owens. And I've said publicly, both prior to now and now, that when we talk about the very limited circumstances, it really is very limited. If you took a look at the prison population of the data that I've been provided, it's in the packet that you have, that you should have. Does everybody have? Okay. Of the individuals that are, well, let's just go ahead and refer to it directly. Of the 2,672 prison admissions for trafficking, just the one condition of meeting the no prior felony, there are 129. I wasn't a math major in school, but I think that's around less than 5%, I think. And that's just on the one condition of no prior felony. So then you get into the situation, well, it's not just no prior felony. There's no weapon, no death or serious bodily harm. The defendant and the defendant wasn't leader of the criminal conduct, and that's a defined term within the legislation. So you'd have to think intuitively that number gets even smaller. And that is in part by design, because it's the sense of the General Assembly, and I believe in partnership with the governor, that by and large, this kind of discretion, while important, needs to be used sparingly, and that it only needs to be used for very specific individuals in very specific fact situations, but that it should be available where necessary. And my understanding, and I'll turn it over to Chairman Boggs, my understanding is over the course of time we've had individuals in the system who potentially have been thrown in there. They're nonviolent offenders. They're taking up the hard beds inside the wire, as I quote, Commissioner Owens, and perhaps that space needs to be reserved for a more hardened, violent criminal who is a threat to society. That, of course, again, is a judicial decision. That's why we have judges. So with that, let me ask, just by way of opening, to Judge Boggs, we'd appreciate having set the table in terms of what the motivation is, or hopefully set the table on the motivation of why we have this discretion. I'd like you to get into what you found during your work on the council. Everything's a learning experience, even for those like Judge Boggs, who, former Superior Court Judge Dana Waycross, ran a drug court program down there in South Georgia. But I know that there was a lot of data that was thrown your way during the council analysis process that has led into these conclusions, and we'd appreciate your perspective on what you heard, what you learned, and then how we got to this point today in the context of this data that I think is compelling. So with that, Judge Boggs.
Thank you, Mr. Chairman and members of the committee. I'm honored to chair the Governor's Council on Criminal Justice Reform this year with Thomas Worthy from the Governor's Office, and of course served on the Criminal Justice Reform Council last year. You will all recall that last year we predominantly dealt with adult criminal justice reform in 1176. I'm very appreciative for your support of that bill and efforts, Mr. Chairman, and also the efforts of the General Assembly in unanimously passing in the House and Senate 1176. We are already seeing, I hope you will appreciate this, we are already seeing in the Department of Corrections realized savings, cost savings as a result of a bill that's only been in place now for about 7 months. So you are to be applauded for that, and I appreciate your efforts. We were asked again this year to reformulate the Council on Criminal Justice Reform. It expanded from a 13-member council to a 20-member council, made up of many of your colleagues, made up of Senate members, made up of many members of the judiciary, criminal prosecutors, and we had a thorough vetting of the issues that are presented in 1176 last year, and again, we're asked this year to deal almost entirely with juvenile justice reform. And I had the pleasure on Tuesday of presenting the council's recommendations in the juvenile justice arena that are all contained within House Bill 242 that Chairman Willard will be, we hope, reporting out next week and voting on. The public comment sections or portions of the consideration of that bill are now over, having concluded yesterday. But it was my thought that as chair of the committee this year that we revisit some of the issues that were contained in 1176 relative to adult reform measures and see if there was anything else that we could do that would ensure public safety and take a very serious look at the fiscal considerations of what kind of return of investment Georgia taxpayers are getting in the criminal justice arena in this state. And to that end, we again explored through a subcommittee of our Council on Criminal Justice Reform some additional issues that are contained in the report that we have submitted to the General Assembly dated December 12th, and I believe you have a copy of this report in your file. That report, again, is predominantly dealing with juvenile justice reform, but I've asked Brandy to pull out the adult section, and you have that as well. The adult section of that report is contained on pages 20 through page 26. So basically, those are the only pages in the report that deal with what I'm here to talk about today. Understand that we made 9 recommendations in the report relative to continuing criminal justice reform in the adult arena. We have, after considering the wishes of Brian Owens and the Commissioner of Corrections, and Brian, thank you for being here, and thank Jay Sanders from the Department of Corrections for your leadership and assistance with the council's work. But those pages do not contain all 9 recommendations, because some of those recommendations are going to be, well, let me start over. The pages do address all 9 recommendations, but all 9 recommendations are not in House Bill 349 that you have before you, because some of those matters, 3 in particular, that I'll refer to later, are handled administratively, we think, more appropriately. So what you do have in House Bill 349 are 6 recommendations, and including the one, Mr. Chairman, that you've just alluded to, and I'll go through any of those that you desire. Wilson v. State issue was one of them that's already been addressed by the Prosecuting Attorney's Council, but I'll address the mandatory minimum portion if that's where you'd like me to start. I will draw your attention to the limited pages that you have, and the recommendation on mandatory minimums is found on page 24, recommendation number 5. I think it's very important for you to and I will try to be as concise and clear as possible. This is not the easiest thing to explain because there's an awful lot going on here. But I want you to understand the impetus for this recommendation was as follows. First, last year, the recommendations from the council were that we do the very same thing that we are doing this year, and that is address a deviation from mandatory minimums in the area of drug trafficking offenses. And I'll address those where they are in the bill. They start on page 6, line 193, and they go through page 9 of line 302. And that's the drug trafficking portion. In addition, and that's handled a certain way. In addition, we were asked to address mandatory minimums relative to serious violent offenders, sex offenders, and repeat offenders. And those are in the bill as well, but they are dealt with a little bit differently. Interestingly, if you will start on line 193, and Mr. Chairman, you are correct, the precursor to any appropriate or allowed deviation under this bill, that is for a judge to deviate from a heretofore mandatory minimum sentence, first the judge would have to conclude 5 particular things. First, that the defendant was not a leader of the criminal conduct. The defendant did not use a weapon during the crime. The criminal conduct did not result in death or serious bodily injury to a person other than a person who is a party to a crime. The defendant had no prior felony conviction. And lastly, that the interest of justice will not be served by the imposition of the prescribed mandatory minimum. Indeed, Mr. Chairman, you are correct that pretty well emulates federal statutes relative to the ability of federal judges to depart from mandatory minimum sentencing. I will read to you from 18 U.S.C. section 3553, and the judges in federal court have to find that the criminal defendant has only one criminal history point. If any of you, like me, have ever dealt with federal criminal appointed cases, you know that that generally means the defendant is not a prior convicted felon. Second, the defendant did not use violence. Next, that the defendant or that the offense didn't lead to death or serious bodily injury. Next, that the defendant was not an organizer, leader, manager, or supervisor. And in essence, that the ends of justice would be met. So we're not really replowing new ground, Mr. Chairman, in the area of mandatory minimum deviations for drug trafficking. Well, why might the council even be considering it? And I think there are a number of answers to that. The first is probably that there is a general consensus among the council and among the Department of Corrections, and as proven up by the data, that our drug trafficking statutes are very rarely capturing the kingpins, who we were intending to capture. What we are capturing probably as a trial judge, I can tell you in my personal experience in 6 counties as a felony trial judge, you're generally catching the mules. The folks that know this stuff, and they are the kingpins, know what the mandatory minimums are for certain levels of quantity of drug for certain offenses, are not going to be caught with 28 grams of cocaine. They're generally going to enlist the services of a young offender, a young individual, and use those individuals to carry the drugs. And that's who we're generally catching. I did ask at the chairman's request that the Department of Corrections look at their 2012 prison admissions for trafficking. Mr. Chairman, you have referred to those numbers. There were 2,672 prison admissions for trafficking in 2012. 129 of those had no prior felony convictions. Now, if you added, in addition, as you are correct, Mr. Chairman, all of the other criteria, the number of people that we're probably affecting by this bill, if you were to pass it relative to drug trafficking mandatory minimums, would be relatively small. Yet, it is important for each individual case to be decided on its own merit and to give judges discretion in deciding what is an appropriate sentence. This bill does not abolish mandatory minimums for drug trafficking. Indeed, all it does is sets a lower minimum threshold that the judge could consider under appropriate circumstances when all 5 of these criteria had been met. And even then, the judge is not required to deviate from the current mandatory minimums, only that the judge may. I think that's very important for you to know, and if you look on line 193, it says the judge may depart if the judge concludes, and then those 5 criteria. So that was the impetus.
And they serve every day of that sentence.
They are not eligible, even if given under this statute a mandatory minimum sentence that is lower than the current mandatory minimum sentence, they will still not be eligible for parole, earned time release, or otherwise. They're going to serve every day to the door, of course, only giving them credit as the Constitution and law requires for time served in the county jail prior to their conviction. But now, having said that, let me walk you through, if you will allow me, starting on line 203 of page 6, where we get into the sentencing departure ranges. Please understand that we have mandatory minimum sentencing in the drug trafficking world that runs the gamut from a 5-year mandatory minimum sentence to a 25-year mandatory minimum sentence, depending on the drug and depending on the quantity of the drug. For example, we have a 5-year mandatory minimum sentence for marijuana between 10 pounds and 2,000 pounds. That's current law. We have a 7-year mandatory minimum sentence for marijuana between 2,000 and 10,000 pounds. We go to a 10-year mandatory minimum sentence for cocaine and methamphetamine or amphetamines between 28 grams and 200 grams, or manufacturing over 200 grams. We go to a 15-year mandatory minimum sentence for cocaine between 200 and 400 grams, methamphetamine or amphetamines between 200 and 400 grams, and between 200 and 400 grams of meth or amphetamine manufacturing. And then 25-year mandatory minimum in current law for morphine or opium over 28 grams, or cocaine over 400 grams, or methamphetamine over 400 grams, or the manufacturing of methamphetamine or amphetamines over 400 grams. So that's why this looks so cumbersome. I've gotten it broken down in the bill and can walk you through that. But as you are correct, Mr. Chairman, all that is being proposed relative to mandatory minimums in the area of drug trafficking, and in each of these drugs that are in current law, is you take the bottom end, whether that's 5 years, 7 years, 10 years, 15 years, or 25 years, and allow the judge to depart 50% downward where those 5 criteria have been met. And I can walk through that. All of that starts on line 205 of page 6 and runs through line 240 of page 7.
Judge, I mean, as long as members of the committee understand that it remains consistent throughout the bill that the downward departure, where the defendant has met all the criteria and where the judge may exercise this discretion, which he or she may or may not, depending on the facts of that particular case in their judgment, that range does not deviate from 50% of the minimum mandatory to the full minimum.
In essence, it lowers it maintains a mandatory minimum in drug trafficking offenses across the board at 50% of what they currently are now, but only for a select group of people.
The contrast comes when we're taking a look at serious violent felonies,
yes,
which are serious violent felonies, and the deviation that we've made there, that the governor has proposed, is given the fact that it is that we are talking about a serious violent felony, that downward departure in the sentencing would only occur if there is agreement between the prosecutor and the defense lawyer, and of course the defense, and then of course accepted by the judge. That is obviously a higher threshold. Why? Because it is a serious violent felony. Is that
yes,
correct?
It is. So as I stated earlier, we're dealing with mandatory minimums 2 different ways, lowering by 50% only in certain cases the mandatory minimum in trafficking, and that, as I've told you, is all of lines of the last part of Section 4, all the way through 251 of line 8. Section 5, because it deals solely with ecstasy. Ecstasy is dealt with differently than in 161330. Ecstasy had to be pulled out separately, but Section 5 only deals with ecstasy, as is dealt with in Section 16-1331.1 of the Code, and it tracks the exact same language in the preceding section relative to all of the offenses for trafficking within 161330. Then, and I think it's also fair to note, although not probably as significant, that in addition to allowing a judge to deviate downward 50% on all the drug trafficking offenses, the monetary fine could be lowered by 50% as well.
Thank
that's
you
in, that's
for making
in the
that
bill
clear.
as well.
Mrs. Cooper has a question.
Sure. Representative Cooper.
Hi. Thank you, Judge. This is clarification, and I'm one of the non-lawyers on the committee. Are there no felony convictions that would fall into like more civil? I'm just asking, and that would be sort of wouldn't sort of be indicative of bad behavior.
As bad.
As bad a behavior.
If I understand the gentlelady's question, it really goes to no prior felony, and if you're saying,
Blanket.
does that it's any felony? It could be felony shoplifting. It could be, it's any felony.
Well, I understand that. I was just
Okay.
asking if there was any, like maybe not paying your federal taxes. I mean, I didn't know if there was any that were of
A lesser?
a lesser type thing, since this only helps about 129 people, and I just wondered if there was.
Well,
I'm sorry about being an on.
No, but please don't. It just to be clear, it doesn't really help anyone. It just makes them eligible for the opportunity to have the judge hear them out on a particular request for that kind of reduction.
Right.
But there's absolutely no guarantee whatsoever. The judge, there's a plausible situation where you could have 100 people out of 2,700 or whatever it is, and they all meet the criteria, and all 100 of them could be denied by the judge. That's certainly possible. It's not likely. But to answer your question directly, as it relates to the no prior felony conviction, the felony's a felony, whatever that felony may be.
Yeah. Thank you, Mr. Chairman. So you now understand.
I want to make sure, Mrs. Cooper, is that clear?
I guess what I'm trying to ask is, it's like sometimes on the nursing board, if somebody has had a minor, something has happened in the past and it was considered a minor thing, then they will look at it. And what I want to know is, Judge Boggs, can you have a felony conviction for something that is not like selling drugs or something that's more in the civil? Can you have a felony for not paying your federal taxes or something that would be on your record?
Sure.
Okay, so if
Could
somebody
be a federal offense, likely, and not a state offense if it was federal taxes, but nonetheless, it would be a felony.
would that keep them from being eligible?
As I understand the nursing board and the boards to which you refer.
No, but I mean, like,
yes, they would not be eligible, but there's no mandatory minimum in those sentences typically either.
But that would, if they then came and did this, it would preclude them.
Oh yeah, if they had a prior felony, it would preclude them from consideration if they were
Do you understand
subsequently
what I'm
to engage
trying
in
to
trafficking.
ask now? Even though it was of a totally
To answer your question, if someone had a less severe felony conviction in this state, they would not be eligible for a downward deviation of up to 50% of a mandatory minimum if subsequently arrested for and convicted of a drug trafficking offense under this bill.
Yeah, I've got it.
A felony is a felony for purposes of this bill.
That's what I wondered, if there were, if we were taking a little bit more discretion away from the judges than we should. But I understand that there is federal law. Thank you.
No, I mean, I appreciate the question, and it's important to have clarity on that. If anything, we're restoring the possibility of discretion.
At least
I think.
some.
Right. Some. Mr. Pack.
Thank you, Mr. Chair, and thank you, Judge, for all your work on this very critical issue, I think. I'm a signatory to the bill. I fully support reforms like this. Two questions, one related to the mandatory minimum safety valve, and the other one related to the violent felony one. For example, in line 193, we have, it's solely on the court's discretion to qualify for safety valve, go below the mandatory minimum if he or she finds that the defendant meets all the criteria.
Indeed.
And at the end, for example, line 241 to 244.
Direct appeal for the state.
Right. The question I have is, I think that allowing the state to appeal that, I understand, it's a good thing. Make sure that there's not a complete variance. The issue I have is if if it's solely the judge's discretion, the standard review on your court, when you're considering whether or not the judge exercised his or her discretion correctly, I'm thinking that might be a very high hurdle for the state to overcome, even if the judge makes a factual finding error or something related to a misinterpretation of the law. Has the council given any thought as to what level of deference that the Court of Appeals should give to the sentencing judge?
The short answer to your question is no. The explanation is that this direct appeal would be favored no more appropriately at any appellate level than any other exercise of discretion by our criminal trial court judges. That is, the standard of review would be an abuse of discretion, as it is for 99% of every other decision a trial court makes. There was no effort made to carve out a separate standard or higher or lower hurdle for the state in appealing the judge's exercises of discretion relative to mandatory minimums. But it is important to note that as a procedural safeguard, there is a direct appeal, whereas without the language on line 241 to 244, there would not be. It would be by application, which means you would again have to convince the judge to grant you a certificate of immediate review.
The reason I bring that up is in my prior life, and I'm not saying that I was never a state prosecutor, so I don't know how it works in the state, but with the judge having so much discretion from the front end whether or not somebody qualifies for a safety valve, I found that oftentimes it undercuts the ability for the prosecutor and the defense attorney to say, I think you qualify for a safety valve, and I might recommend it with you if you were to cooperate, you're able to build up the case going up. If there's such a wild card factor in the front end, we might be doing a disservice to an efficient way to dispose of several cases and getting cooperation from lower level drug traffickers.
Well, nothing in this bill would prevent the DA from working out a deal to solicit information from an offender and allow them to plead to a lesser included offense to which a mandatory minimum does not apply in exchange for their testimony against co-defendants or other parties. So that's still available. But yeah, indeed, judges have discretion. I mean, right now, possession of cocaine is 1 to 15 years until we get to the weight portion. That's an awful lot of discretion in a Superior Court judge, but I think it's an appropriate exercise of discretion, and it ought to be placed in the person who is most capable of making that decision. And so in the end of the day, the DAs, under your analysis, would still have that authority because they're not married to they may indict an individual for trafficking, and to the extent they want to, that individual wants to plea, this would allow the judge to deviate if the criteria is met. But another avenue of resolving and disposing of that case would be for the DA to allow them to plea to a possession, in which case the mandatory doesn't apply, and they can get an exchange and agreement.
Another possibility, and I appreciate the Vice Chair because he touched on a very important point, is the possibility, and there's been some conversation in the last day or so about, on the drug trafficking piece, allowing for the possibility of, if they don't go ahead and meet, if they don't meet all the conditions in order to get or be eligible for the downward departure in the sentence, is to simply put in a clause of or with the agreement of the prosecutor, because you could have a situation where they come very close but don't meet the criteria. The prosecutor, under what you said before, which is of course correct in terms of, look, this is a low-level offender, but they can lead Mr. McDade and his friends to someone much higher and much more important, within a network or within a cartel. If we were to entertain the possibility of having an or with the agreement of the prosecutor, that actually provides for the possibility of more discretion.
Sure.
And it allows our prosecutors to go ahead and to work up the chain, whereas they might not have had that possibility before.
I do not think, Mr. Chairman, and I thank you as well, Representative Pack, for bringing this to our attention. I do not think that would deviate from the intent of the council, which was to provide discretion where appropriate. It provides more.
More, absolutely.
It allows a district attorney to deviate from these 5 strict criteria where Ms. Cooper's concern might have been addressed. That is, that there's 20 years ago in someone's history, while they were a juvenile, behaving as juveniles do, or not a juvenile sense of elite, but maybe 17 or 18 years old, committed an offense that prohibits them from consideration on a downward departure if they were used as a mule in a drug trafficking case. But the DA might recognize that, and would, under these circumstances, allow it. I think that would be a favorable amendment.
Be far more valuable to the prosecutor working up the chain in a cartel in order to get a downward departure for some low-level offender. I mean, the cost-benefit analysis of that is a no-brainer for them.
And quite frankly, more appropriately, I think, achieve the results that we were trying to achieve on the other side of mandatory minimums, which is to promote this truth in pleading argument. That is, to allow an individual to plead to the offense, or to basically enforce an individual to plead to the offense to which they were indicted and to which the sufficient facts support their conviction, but deviate. and that would allow that as well in this case. So for drug trafficking, that would probably be a...
I'm sorry, interrupting Mr. Pack, but he hit right on an important point.
Thank you.
Direct your attention to lines 186 to 192. That addresses
Does it?
It's on the group. And that's current one.
Right. My point was more directly related to, from the perspective of a defense lawyer, depending on which judge you get, if you know that the judge has a history of following the party's recommendations and things like that, it gives a little bit more comfort for the defense lawyer to recommend to his client that I think you'll qualify for a safety valve. And, I could tell you right now you're going to get it because this judge has done that. But more, if we give the judge in the front end more discretion whether or not to grant the safety valve or not, what I'm saying is that may hinder the calculus a little bit in determining whether or not a client should plead guilty. In the federal system, generally, if you meet the criteria factually, you automatically get the safety valve. And then depending on how far the judge could go down from the mandatory minimum is left to the discretion of the judge, which that, in fact, is appealable based on a very highly deferential standard. So that's what I mean. Not about cooperation, but in terms of recommending to a client to go ahead and cooperate and take the word, to give certain certainty that you are going to qualify for something, goes a long way in terms of negotiating a plea versus, if the wild card is the judge who he or she may not grant you the safety valve, then you're stuck with a bad deal. But I understand Mr. Chair's a very astute comment about you can negotiate around that with contingency. So I just wanted to make sure that was addressed. Second question.
Can I respond to that very
of course,
briefly?
Judge.
Even in those circumstances where predictability on behalf of the defense attorney to try to convince that drug trafficker to accept the deal, we have the procedural safeguard in Georgia, of course, to allow the defendant, except for in a blind plea, to withdraw that plea of guilty if the sentence imposed by the judge is not consistent with what they expected. So unless it was a blind plea, it would be a plea deal worked out ahead of time, and you would know that the judge is going to give you what that plea deal is, and if he or she doesn't, under your scenario, they could withdraw that plea of guilty.
Whether or not it's wise policy, but that's for another day. But,
yes, sir.
The second question related to lines 295 to 302, which relates to the safety valve on. So I'm sorry.
I'm sorry. 295.
I'm sorry. 385 to 392.
Serious violent offenders, yes, sir.
Right. When all the parties agree to the. One concern I have is the victim of the violent crime input is not considered here explicitly, and I'm kind of concerned that it might violate the Victim Rights Act.
We were extremely cognizant of that. If you will read the recommendations, our recommendations were explicit that nothing be done to implicate the victim's Bill of Rights. Jill helped us draft this, and I'm confident that as drafted, it does not implicate or affect victims' rights. The DAs have had a very, very strong role in ensuring that, and if I'm speaking wrongly, Mr. McDade, let me know, but we're convinced that it does not implicate the victim's Bill of Rights. Victims' impact statements and notice to victims of possible deviations, notice of potential court hearings such that they can be heard on judicial discretion to deviate are all still intact.
Can I ask Ms. Travis if she wants to comment on that or hold for future conversation?
385 to 392, is that what your question was, Representative Pack? Because all that language is...
Well, I'm sorry. 381 to 384, which is wrong lines. Which is the
The actual department.
right.
The departure.
Yeah, but there's nothing in Title 17 requirements of 1710, 1.1, 1.2, the victim's rights. None of that is impacted. None of that is changed by virtue of this.
They would still have notice.
Right,
They would still have an opportunity to be heard.
Prosecutors have an obligation to involve the victim. There's nothing that's been changed in that regard.
And if you look on page 24 of the recommendations, council recommends that any legislative action initiated in response to this recommendation afford due and appropriate consideration to ensuring compliance with the Victims' Bill of Rights pursuant to Chapter 15 of Title 17. So that indeed is a good point, but was a concern that we were also concerned with.
Thank you.
Go ahead.
Mr. Strickland.
Going back on what Ms. Cooper was asking, based on these 2012 numbers that we have, do we know how many of these prior felony convictions were non-drug related convictions or non-serious felony convictions? Do we?
Without asking corrections to go back and extrapolate that data and pull it out from what they have, no, sir. And most importantly, I mean, these are low numbers, 129 of 2,672, but as Chairman Golick indicated, that's just applying the one criteria of prior felonies. If you apply all the other, it's going to be a smaller group, but no, sir, we don't know how many of those were less severe prior felonies.
That's not being thought was given to defining felony, somewhat narrowing which prior felonies they could have had.
You could do that. It would, there are a lot of felony statutes on our books, and it would be a relatively difficult task to discern which ones were less severe, which ones were more severe. But I think Representative Pack's concern probably addresses that, and that is at least give the district attorneys an opportunity to, even where there is a prior felony, to maybe still allow deviation if it was remote in time or less severe. Good question. Thank you.
Thank you.
Mr. Sutton.
Hey, Mr. Chairman. Judge Boggs, thanks for being here. It's been a great discussion. On the, again, lines 381 through 392, dealing with the serious violent felonies, what was the discussion about not giving judges the same process that's contemplated under the drug trafficking? I understand if you've got a DA that recognizes that the facts of the case are such that perhaps a mandatory minimum shouldn't apply. I see that discretion being possible. But are there cases where that may be more borderline cases where perhaps we would want to give judges the ability to apply the same measuring stick we did under drug trafficking based on someone not being a leader? My concern is, my limited experience with this, and again, I'm not a practitioner, there are cases where all the elements of a, quote, serious violent crime can be satisfied, but it doesn't meet what the public typically thinks about as a serious violent crime. Accomplices to things like armed robbery, things like that, can get caught up in this. Is there was there just a general disposition to want to do this with drug-related crimes and not delve into the serious violent crimes? Is there the potential to address this later? Or was there a very strong inclination to not let that same rubric apply to violent crimes?
Indeed, that was part of a very lengthy discussion by the members of our council, and there was not unanimity on how we approached this last year, where we dealt with mandatory minimums before, nor this year. I think, in short, there was probably a consensus that there was not the political will quite yet in place to go as far as you suggest with respect to the serious violent felonies. Those felonies obviously typically involve a victim. They are typically much, much more severe with respect to their impact on the community. There was a lot of discussion about that, Representative, but in the end of the day, we felt like, as a council, that this was a more appropriate and measured approach to deal with serious violent felonies at this time. And I can't tell you that there's going to be political will later. I hope there will be. As a former sentencing judge who has had the displeasure of having to deal with a mandatory minimum sentence in a case that, quite frankly, based on the facts and circumstances, did not warrant a 10-year mandatory minimum sentence on a 10-year mandatory sentence on an armed robbery for a 17-year-old honor student in high school with no prior felonies. I can see on certain occasions where the imposition of a mandatory minimum sentence is not appropriate. I was not a liberal sentencing judge. I just believe that as a judge you have the opportunity to weigh the credibility of witnesses, to judge the weight of the evidence, and that some due deference ought to be given to the individual in that position. But having said that, the 7 deadlies, the serious violent offenses, are quite distinguishable, I think, from the drug trafficking offenses. I would like to see, personally, the state move toward providing more discretion to sentencing judges, because no case is the same. All cases are different. But in the end of the day, I think there just wasn't the will to do it at this time.
And I raise that question. We all have 4 examples, of constituents and folks we know. There was a young man in my community that became addicted to some drug that he could get at I don't think it was some kind of prescription drug. Walked into a drugstore, gave a note had no firearm, but of course he gave a note saying that he had a firearm to the attendant. Might have been a pharmacist or somebody. Got the drug, went to another drugstore, did the same thing. Because there were 2 cases in the same day, he wasn't able to use a first offender arrangement because he did it in 2 circumstances, and went through the whole process of rehab. Was a model model patient in rehab, really almost the poster board case of this. And when it finally came down to trial, it became a mandatory minimum sentence of 10 years. That was the reality. He's back integrated into life again. I've seen this, but that's an example of a case. Perhaps the DA in my circuit in Cobb County would have said, "Okay, we'll work with you on this one," but that might not be the case everywhere.
Yes, sir.
And I raised that. It's on my radar screen, and I appreciate your consideration.
And it's gentleman's point's well taken. That really is a very much was and still is a focal point of the debate. And I think the balance that what we've struck here is that where you have a situation like that, it's a perfect example that you gave, Mr. Sessler. You hope that you have a district attorney who understands the use and power of discretion where it's appropriate, and where you under the governor's proposal, you strike that balance where you have, of course, the defense, but more importantly, the prosecutor and the judge all agreeing on an outcome. If you have that triumvirate in agreement, chances are the interests of justice are being served.
Very, very good point. In the end of the day, I believe you could find significant anecdotal evidence throughout the state by asking legislators who are contacted by families of these people, judges who are involved in sentencing these people, even DAs. I mean, discretion is a broad term, and sometimes it can be abused by judges. It can also be abused by prosecutors. No one discounts that. We're a large state. We have 49 judicial circuits. We have 200 and I think now 6 Superior Court judges. What is politically palatable and acceptable in one geographic region of this state may not be in another. And taking all of that into consideration, we believed as a council that this was a measured and appropriate approach. So thank you for the question.
And Mr. Chairman, I'll just conclude by saying to the judge's point, when you think about the equal applicability of the law, I mean, this is a human endeavor. I mean, judges aren't all the same, prosecutors aren't all the same. But when you've got a person in one part of the state that does something and is able to get an agreement by that triumvirate you talk about, in another part of the state, perhaps something might be even lighter in terms of the facts of the case that couldn't get that agreement, you begin to wonder in this big diverse state we're talking about, is there equal application of the law? And that just, I just raised that as a question.
Very good point.
Good question. Mr. Coomer.
Thank you, Mr. Chairman. I have questions about other portions of the bill. Is this the appropriate time to bring those up, or are we just focusing on this section at this time?
I think,
I can walk you through the rest of them pretty quickly.
Well, let's hold for a second.
Sure.
Let me ask you, I mean, I think we've done the due diligence on the drug trafficking and the serious violent felony piece, but let me ask if there are any members have any other questions on those particular provisions. Seeing none, I wanted to point out what I am going to ask you is to give us clarification on in a moment on the probation supervision piece. My sense is that it's more of a clarification than anything else, but I think it'd be helpful for you to walk the committee through that.
Okay.
On the limited driving permit piece, which is on.
That is page 17, section 12, and page 13. Section 13, page 19.
As we understand it, I mean, this will allow for those individuals who are drug court participants, it'll allow the supervising judge within that drug court to issue a limited driving permit as part of the individual's rehabilitation and their participation in drug court. Is that correct?
Yes, sir.
And last year, Senate Bill 236 from Senator Calzert provided for that exact same thing, but in DUI court,
yes,
and we didn't include it in drug court. This will simply be the drug court application of that.
Yes, sir. In many instances, many participants in drug courts have had their licenses suspended not because of DUIs, but because of violation of the Georgia Controlled Substance Act, which is a mandatory suspension. And so they come in there with a myriad of obligations, including showing up for random drug screens, maintaining employment, showing up for court sessions, and all of which are dependent on their ability to be able to get around. And so this would simply mirror the work permit, for example, that is currently permissible under Georgia statutes for judges under appropriate circumstances to give limited driving permits. And it would be for employment purposes and for compliance with drug court or mental health court.
Right. If anything, it's a mechanism to ensure, within that defendant's participation in the drug court program, the culture of compliance in their head, yes, to go and get them. Because drug court is no small task.
And it would be permissible. Judges would have the ability to use the issuance of a limited driving permit as a reward for a participant doing well in drug court, but also could revoke it as a sanction on a limited basis. This is not, however, going to allow a judge to unrevoke a suspended sentence. It's only for the issuance of a limited driving permit, and that's really what we're talking about in that section.
Are there any questions about that particular section on the limited driving permit? No.
I was actually had one on the traffic.
Oh, okay. Let's let me recognize Mr. Hightower for another question on the trafficking piece.
Going back to what I originally brought up when Mr. Spahos was up here, I've got them to bring me a copy of the Wilson v. State case,
Yes, sir.
and then also read through the rest of this section and looked at the prior code section. From what the Wilson v. State, what I'm gathering out of it, it says a lot of this is coming from where they directly tell us, the General Assembly, look at this. And then it says, consequently, the issue of whether the state needs to provide that it prove the defendant knew the quantity of the drug in order to be convicted of trafficking is subject to reasonable dispute. When I read that, I see the problem and see what they're wanting us to do. When I look back, though, at this section that we have in Section 4, and I look at lines 90 and 91, and then again at line 104 and 105, I'm still having a tough time with the knowingly at the beginning of the sentence coming out. I understand the second knowingly as it goes to the possession. I understand in subsections B, subsection C, subsection D, subsection E, there is no knowingly in those portions of the sentence when it goes to possession. What I don't want us to do is right now any person, the way it reads now, any person who knowingly sells, manufactures, delivers, or brings into the state, the knowingly is there. It's not so much the sale and the manufacturing that I have a problem with, but it's the delivering and bringing into the state and not having knowingly attached to those, where you may have someone who has no idea that what they're delivering through no fault of their own. You can imagine any type of scenario where you have a family member saying, hey, I needed you to deliver this to one of my buddies. They know the family member well. Sure, Uncle Bob, I'll go and deliver this for you. And they go and deliver that package. Well, unbeknownst to them, it's whatever controlled substance it may be. We're taking the defense of knowingly out of there. Now, just because they simply delivered this, they're guilty. So based on if we make this type of change. But when I read Wilson, I don't believe their issue was with the knowingly part of sales, manufactures, delivers, or bring into the state. Their issue in this and what they were wanting us to address was the knowingly as related to possession, the amount, so to speak. At least that's what I've gathered from reading this. If we strike the knowingly at the beginning of the sentence and fix it that way, we're taking a very large defense away from people who had no idea what they were doing. At least that's how I read it.
Let me respond this way. Please appreciate that this case originated in the Georgia Court of Appeals, went up on cert to the Supreme Court. I have purposely stayed out of the debate concerning how to fix what the Supreme Court suggests ought to be fixed. I'm not going to take a position on your question. I think that question is more appropriately asked of the prosecuting attorneys, but it would be a violation of my oath to do that, and please respect that. I understand your question, but I can't go there.
I understand. I understand.
Let's do this on the knowingly piece. I think we have an issue there. This is exactly why we have hearings like this. Okay. So we'll take some time, step back over the next few days, and just work through it.
Yeah.
And
Judge,
make sure we have a meeting of the minds.
I know you weren't.
There, he just asked if we have any questions on the trafficking, and
No,
we moved on. I want to bring up that.
We have to keep the judges on their toes, so I think it's I think it's an important exercise.
I might recommend you look at 161330.
Okay. Thank you.
Mr. Coomer, you had a question, and I don't want to forget it.
Yes, sir. Thank you, Mr. Chairman. My question goes to Section 11, pages 16 and 17, which has to do with the testimonial exceptions for minor victims. And
Hang on, Mr. Coomer, if I can interrupt you.
Yes, sir.
That's not part of the council's recommendations. I would not be able to give a response to any question you might have of me, and I would ask if you've got any questions concerning Section 11 that these two gentlemen come back up to maybe answer your
Yeah,
question.
they testified to that before, but I know you couldn't be here, but I do want you to ask your question if you have it now, and then I'll just ask Mr. Spehaus and Mr. McDade to go ahead and come on up and respond, and we can play musical chairs if we need to. It's fine.
Sorry to interrupt.
Thank you, Judge. And to give a brief background, I've both prosecuted and defended child sex crimes cases, and have come across this issue a few times in practice. But and I understand the policy behind the exception, but I have a problem, particularly with line 566. Such child has a physical or mental disability, in that you could be essentially, excuse me, carving out an exception for a child who may be deaf or who has ADD or suffers depression. And that may be a broader exception than this committee really wants to create. To that extent, I would suggest that we add some language that addresses a sort of a limitation on that exception. And I happen to have some language I'd be glad to read out loud, and then we can take it up at an appropriate time. But what I would suggest is adding the word, after the word disability, adding words that substantially impairs his or her ability to testify, provided no substantial impairment will be found if reasonable accommodation would render the child capable of giving testimony. In other words, if they're disabled and that disability does affect their ability to testify, then there should be an exception. But if that disability is one which could be overcome by reasonable accommodation, such as a person who could do sign language, then there should be an accommodation and not an exception to that child's in-court testimony. I'm sorry? Right. So a child who may have some disability, but that disability doesn't affect the child's ability to testify. I wouldn't want that to be an exception to the rule. And then also on line 569, with again, I understand we want to create some flexibility in the rule, and I understand there's a reason for that. But line 569 to 571 says that if there's a substantial likelihood that such a child would suffer severe emotional trauma from testifying at the proceeding, or by way of means of two-way closed-circuit television, then the exception would apply there. I would to tighten it up a bit. And I think my friends from the prosecuting counsel probably won't like this, but I'm going to suggest that what we would do is strike the words there is substantial likelihood, and replace that with the words the prosecutor shows by a preponderance of the evidence. In other words, we're going to require some showing, something to hang our hats on, for lack of a better term, to show that there is a severe emotional trauma that's going to inure to the child, or that is likely to inure to the child, rather than just having a judge sort of shoot from the hip and say, well, yeah, I think there's a substantial likelihood, and open that exception up more than we really want to do as a matter of policy. Those are my two questions, comments, suggestions.
Thank you. I'm going to call on Ms. Bellinger in just a second, but I wanted to see if the prosecutors had any immediate response to that from a policy perspective, or they just want to reserve the right to think about it and get with Representative Comer.
Either way, Mr. Chairman, I mean, we clearly believe that the prosecution has got the obligation to establish all of this. This wording has come from an analysis of a lot of the cases, particularly federal cases that have kind of laid out these, and that's kind of where we've mirrored some of this from. But we're more than willing to sit down and talk about anything we need to do to narrow it. We certainly do not want to create an exception that wouldn't withstand judicial scrutiny.
Okay, thank you. Ms. Ballinger.
I'm not really sure how we would establish if we were to require some kind of, I mean, obviously, if we were going to, have some kind of burden of proof placed upon the prosecuting attorney in those sorts of cases, the establishment of that would be by the child testifying at the hearing, that I'm going to be traumatized if I testify. So I'm not really sure, we're trying to, the child's already been traumatized, I mean, they've suffered an act that was just more horrible than, I think anybody in this room can really imagine. So, to me, we're just re-traumatizing, the trauma that we're trying to prevent, we would just be basically inflicting upon the child by requiring an evidentiary hearing.
I think, in motion practice, you don't necessarily have to have the child there to testify in person. You could have a medical expert offer an affidavit, perhaps, or you could have a medical expert available for cross-examination also. But there should be some showing that there should be some definitive showing that the child would suffer severe emotional trauma. But I don't think you'd have to necessarily do that. And again, from my practice, you wouldn't have to do that with the live testimony of the child. I mean, you might do it. There are any number of ways to do it that wouldn't require the child to testify in person. And clearly, if you're trying to show that testimony would cause severe emotional trauma, you wouldn't want to show it by having the child come and demonstrate severe emotional trauma. I don't think that would be effective. It wouldn't be what anybody would want to do. But I do think you can demonstrate that that likelihood or that potential for severe emotional trauma without having the child have to actually go through the trauma of testifying.
Yeah, I mean, I think just having dealt with those victims, it just seems very kind of rudimentary and very simple how, having to testify in an open court of law, to confront the victim, to and confront the defendant, how can that not be?
Well, and again, anecdotally, I guess, from my experience, I've had cases that were on the less severe end of the spectrum where children were truly traumatized by the prospect of having to testify. And I've had cases that were very severe, and the child testified. It was like talking about what they had for lunch. I mean, I don't mean to demean what happened to the child by that, but I'm saying there are cases where a child has been a victim of a crime, but testifying about the crime is not going to create a new traumatic event for the child.
Mrs. Cooper. Mr. Pack.
To follow up on the question that I had before on line 575 to 576, as I read this provision, subsection B does not require that child to be present at the trial. Am I right? Is that how I read it?
That's exactly what that's intended to do, is to establish an alternative means for the child's testimony.
Okay. I see that two-way circuit closed television, you could have a contemporaneous questioning of the child, but the deposition is provided by Article 613. Was there a case that allowed that under the Sixth Amendment Confrontation Clause?
When you actually go to Article 6, Title 13, if that goes to our criminal deposition statute, which I'm pretty certain it does, you've got to lay out all that criteria, and you have to provide opportunity for cross-examination.
That's what I was trying to get. Okay. Thank you.
Good discussion. Judge, you want to briefly fly through the probation supervision piece at Section 6, is that right?
Yes, sir.
Okay.
If you'll, this is on page 10, lines 339 through 347. It appears as recommendation number 2 on your handout, page 22 of the report of the special counsel. And let me give you a little bit of data. The recommendation is to revise the definition of administrative probation, which would allow the Department of Corrections to focus its resources on high-risk offenders. The real gist here is to more closely or more clearly delineate the responsibility of the Department of Corrections relative to administrative probationers. And the data is this: the population of probationers in Georgia has grown 29% in the last 12 years. We have 164,000 probationers with approximately 10 million people in this state. Comparatively, Florida has the same number of probationers, 165,000 probationers, with 19 million, nearly twice as many citizens in that state. We don't compare very favorably based on number of probationers versus the number of citizens. Part of that growth in Georgia is due to the length of probation sentences. In Georgia, probation sentences are nearly twice as long as the national average. 6.83 years is the average length of probation in Georgia, compared to 3.2 years nationally. We have very, very lengthy, comparatively long probation sentences. The national standards for supervision for your active probation caseloads are as follows. For your special offenders, those are those that are on intensive probation supervision, sex offenders, and those in a day reporting center, is 20 to 1. That ought to be the ratio as between probation officer versus offender. 20 to 1. In Georgia, the current numbers are 58 to 1. For high risk offenders, the number on average, the national standards suggest that the number should be 50 to 1. We're at 58 to 1, so we have a little worse ratio there. And on standard probationers, the national average is 200 to 1, and we're at 287 to 1. As you all may remember, in 1992, this General Assembly addressed a length of probation for the last time. Has not been addressed since then. And during at that time, we promulgated statutes that allow an offender after 2 years of satisfactory supervision on active probation to be removed to administrative probation, where the obligations of the offender are less. We have roughly 63,000 offenders in unsupervised or administrative status in Georgia, 63,000. Of those, the recidivism rate for those as compared to active probationers is quite marked. The 63 offenders have a recidivism rate of 18% of rearrest, not probation violations, versus 60% for active probationers. In short, and the Commissioner of Corrections is here if you have any specific questions, but in short, as presented to the Council and as considered by the Council, there are a myriad of obligations that probation officers have for this class of administrative probationers. You might not think that there's much that a probation officer has to do, because administrative probationers are relieved of an obligation to report to a probation officer. There are many things probationers do not have to do as a result of being on administrative probation, which again is authorized after 2 years of active probation. But one of the problems we have is under the Interstate Compact, as the 63,000 inactive but administrative probationers in Georgia wish to move, for example, they have to apply to their probation officer years later, while they're still on probation but on administrative probation, for permission to move under the Interstate Compact. And paperwork has to be filled out, and there are a lot of obligations that these probation officers have vis-a-vis the administrative probationers that takes time away from dealing with the offenders that really need the supervision, and that is predominantly your special sex offenders and intensive probation offenders and your high-risk offenders. And so we're really not suggesting in our recommendations, nor is what is included in lines 339 and 347, that we do anything other than change that term administrative probation to unsupervised probation, which under the Interstate Compact would allow, as I understand it, more clearly delineate the role of corrections relative to compliance with the Interstate Compact and a couple of other things. It does not really change the status of that offender or the obligations of that offender, nor would it change, for example, that if while on probation, administrative or otherwise, if that offender committed a crime, there's going to be a detainer placed on that offender, and the issue of revocation of probation will still be eligible for the court to consider. But this is basically an opportunity to alleviate some of the obligations, non-consequential, quite frankly, obligations that corrections has. You should be aware that there are significant costs associated with getting up to standards, if you will, for supervision levels. If you do nothing, and based on anticipated growth of Georgia's prison or probation population, which is now at 164,000, to come within the standards of supervision as promulgated by the National Probation Association, you would need approximately 204 officers at a cost of about $11 million. And so this is an opportunity without fiscal impact to shift some of that responsibility so that these offenders can be supervised and our limited resources in the nature of probation officers can be targeted to the most serious needs.
So the bottom line is that we're going to go ahead and, for those that are unsupervised, we're clarifying the definition so that corrections can get out from under the paperwork that goes along with that 63,000. It doesn't change the responsibilities of the probationer. They have every opportunity to go ahead and to have their probation revoked if they get off the straight and narrow, and they can go ahead and refocus their efforts where it's more impactful. Any local impact?
There's been none articulated to the court. The ACCG has been very instrumental and involved in the work of the council. They've not indicated any concerns whatsoever about a shift of burden or a unfunded mandate of any sort as a result of this.
Questions?
These are all state paid, correct, probation
Right.
officers.
Questions on Section 7? See. Yep.
Mm-hmm. The statistics you referenced, do you have that same kind of information on the average time of sentence for felons in Georgia?
Yes.
Versus other states?
I don't have it with me, but I have it available and be happy to share it with you.
Sort of qualitatively, where do we stand relative to other states?
On length of sentence?
Yes, sir.
Two-part answer. There is disparity in sentencing in Georgia, which was alluded to earlier, that, for example, the average length of sentence for possession of cocaine in the southern part of the state might be different than in the metropolitan part of the state. And some may allude to that as being significant and an indicator of a failure to protect, from an equal protection standpoint, criminal defendants. I think it is a product of geographics. It's a product of different judges and different prosecutors. But as far as the length of sentences on particular offenses, I could ask corrections to pull that out for you. I know how long. I've got data that suggests how long people serve on particular sentences in Georgia, but not as compared to other states represented.
I'll follow up on that one, Mr. Chairman. That was just
Yeah, I mean, there, of course, the other side of that argument, and there are sometimes several other sides, is the fact that some also would say that that sentencing protocol in that particular jurisdiction is a reflection of community values.
Sure.
As delivered by an elected official who's represented by that community.
And my concern, was, Mr. Chairman, was not county to county or circuit to circuit, but really more Georgia to other states and how we're benchmarked. So.
Understood. Thank you. Judge, thank you. We appreciate it. We're going to go ahead and stay close.
Yeah, I'm here.
Thank you.
Thank you. Thank you, member.
We have three more folks who'd like to be heard. Excuse me, four more folks who'd like to be heard on 349. We have a supposed hard stop of noon. So let me call Judge David Darden from the Cobb County State Court. Judge Darden is also the current president of the Council of State Court Judges.
Thank you, Mr. Chairman. I know you may be a little pressed for time, so I'll be brief with the comment that I have. It's fairly simple. I'll draw your attention to Section 10 in the bill. This is really more of a housekeeping thing. I'd like to make a request for on behalf of the state court. The council's done great work. The Criminal Justice Reform Council has done great work. We have tried to participate. I think this section now codifies, I guess in a permanent way, what has been the constitution of the Criminal Justice Reform Council, and we just like to address what we consider probably as an oversight. Given the charge of the council, it's set forth there in lines 444, 445 through 450. Given that charge of the council, we think it'd be advisable to have a member of the state court on that council. In the last completed fiscal year that we have records for, the state court had 7 times the filings, say for instance of juvenile court, 600,000 criminal filings in one fiscal year. So we think it's especially important to get input from a county level court, the highest volume criminal court in the state, and we would say particularly because of, first of all, the charge of the council to work on issues with regard to accountability courts. DUI courts, of course, are primarily at the state court level. We'd like to be able to stay involved with the evolution of how we continue to work that particular accountability court. Obviously, when we're talking about best practices, again, that's part of the charge of the council. When we're talking about best practices, it'd be, we think, good to have input from the highest volume court in the state. That's, with that volume, the necessity for having efficient best practices is especially important. Third, with regard to the council's interest in working on issues of reducing recidivism, one could make the argument recidivism begins at the state court level with the misdemeanors, and we could address the issue of recidivism well at the state court level. So I know there may be some concern about that the council is getting too large, but we think the issue is not whether it's too large, but whether it's complete. And we think that the involvement of the state courts with the Council on Criminal Justice Reform would be a good idea. I've had some informal discussions with a representative of the ACCG. They're not opposed. They would like to have input from a county court level. So I'll take any questions.
Thank you, Judge. Any questions for Judge Darden? Seeing none. Thank you, sir.
Thank you.
We call on Judge Lawton Stevens, Superior Court Judge Lawton Stevens.
Thank you, Mr. Chairman. And I've got one very small issue which I've talked to the district attorneys about, and we may yet be able to reach a plea bargain on this issue. But if you look at page 2 on section 1, line 44, I don't have a problem with the state appealing a pretrial evidentiary ruling. There's already a right for a direct appeal if I grant a motion to suppress or a plea and bar. But the only problem I have is that all it would require is for the prosecuting attorney to certify that the appeal is not taken for purposes of delay and the evidence is a substantial proof of a material fact. And I would be required to stop the trial. I mean, you know, we look at kind of trained to think in worst case scenarios, and I can see a circumstance where I've made a pretrial ruling some weeks before, come in on Monday with 160 jurors sitting in the room, and the prosecutor comes in and says, Judge, we're taking you up on that ruling on the similar transactions, and there's nothing you can do. You don't have any discretion under this language. So what I would propose is that we make it by certificate of immediate review. In other words, on line 46 where it says if the prosecuting attorney certifies to the trial court, just change the word to proves to the trial court. So right now the defendant does not have the right to a direct appeal of a pretrial ruling. Now I had a circumstance about 6 weeks ago where we had a defendant had a very serious case, moved for a continuance, and I denied it. And so on the eve of trial, and the state had already had witnesses flying in from Philadelphia and places like that, on the eve of trial they filed a motion to dismiss for violation of a speedy trial, a constitutional speedy trial. And under the law, that was an automatic appeal. I had no discretion. I had to continue that case. But under Wozniak versus the state, a case that came out fairly recently, the defendant no longer has that right. They have to proceed by certificate of immediate review. So the defendant cannot delay a trial by filing an appeal. I have to go through the certificate of immediate review, get the approval of the court. So and I just feel that, and the judges feel that the state should be required to go through the same process. In other words, should not be able to file an appeal which obviously acts as a supersedious pre-trial, so that we come in and say, well, you can't try the case. So I would just ask that the committee consider making it, putting it on the same level as what a defendant has, and that is they got to establish some reason why, and not just file a certification and have that be an automatic right of appeal which acts as a supersedious and prevents you from going forward with the trial.
Judge, let me, I think as a preliminary matter, what I'd ask you to do, of course, is to get in a room with our friends in the prosecution community and see what can be worked out.
We have talked, and I feel confident that we'll be able to work something out.
Okay. In the interim, they call Mr. Pack. Sure. Any questions for Judge Stevens? Seeing none. Thank you, sir.
Thank you.
Travis Sackerson with the Georgia Public Defender Standards Council.
Good morning, Mr. Chairman. Thank you for having me. I wanted to say that overall, our agency, I'm the director of the Georgia Public Defender Standards Council, for those of you who don't know me, that there are a lot of really good things in this bill. There were just a very few things that I wanted to address, maybe were confusing. Most of them have been addressed, and so in the interest of time, I will try to be brief. And I certainly I would agree with Judge Stevens, at least on this. It pains me to do so, but I will agree with Judge Stevens. Only because he said what he said when I was walking up. So I would agree with Judge Stevens about his concerns as to the appeals issue. In Section 4, I think Representative Hightower has addressed a number of different ways and our concerns with this. And as by way of introduction, in another life, I too was a prosecutor for about a decade, and I was the drug prosecutor in DeKalb, HIDTA prosecutor. I mean, I've handled hundreds, if not thousands, of trafficking cases, and so I certainly understand what it is that the district attorney was addressing. And certainly I have the utmost respect for Mr. McDade, maybe not Mr. Speos, but certainly Mr. McDade. And I know that he addressed the Wilson issue, and I think you, Representative Hightower, was certainly on point with the Wilson case. It appears was discussing the either precise knowledge, I think was the term they used, about the weight. I think that, and I know Ms. Travis had mentioned that maybe there is some overarching scienter or intent requirement in 161330, but I think there was a reason why that the legislature had repeatedly put in knowingly and knowingly and knowingly. And what I would be concerned about is just what you had mentioned, Representative Hightower, that the strict language would appear that we might be moving toward a strict liability crime or a mere presence crime, that just as you said, at least the language on its face appears to be confusing, and I feel like there has to be a way that we can get where everybody's trying to go with the Wilson issue without also making this appear to be a strict liability crime. And so I think that that on its face, we would be concerned that maybe that's what this looks like. And so as far as when I say confusing, that's really the issue. And the other point that I was going to make really deals with the child hearsay issues, and I think that Representative Coomer addressed most of those issues as well. No one had mentioned the fact that in line 549 we are changing from what is a child from 14 to 16 years of age, and that may be significant that when you're talking about the difference between a 14-year-old, now we're talking about a 15 or a 16-year-old being traumatized. And again, these are not just victims that we're talking about, but now this is expanded to witnesses under the statute. And I do know that the Bunn case that the prosecutors mentioned, it does, the Supreme Court did expand those same protections using the Equal Protection Clause, that if the point of the statute was to avoid children from being traumatized, I think Justice Nami has called court a scary place, avoiding children having to be to go through that process, then that should also apply to witnesses or any children that might be traumatized. And so I think that was part of the expansion. But I just would be concerned about some of the things that are in here. And as you had already mentioned, Representative Pack, the effects that whether some of it would withstand a Crawford challenge. And so that's everything that I wanted to address. And if anybody has any questions, but I really do think y'all have been vetting this, and it would be great to see if we could work out some sort of language fix for some of those parts that may be confusing.
Thank you. Any questions from Mr. Sackerson? Yes, Ms. Ballinger.
As far as the age, changing the age from 14 to 16, doesn't that just bring that alignment into the change that was enacted with regards to the age of consent? Didn't that just kind of follow the change? Correct me if I'm wrong.
I'm not sure what drove that change.
The age, okay. I just thought it was bringing it in line to the age of consent. Whenever they raised the age of consent from 14 to 16, I thought the victim exclusion was just kind of bringing that in line with that, the criminal prosecution.
Do y'all want to speak to that or not?
Mr. Chair, we do agree that the raising from 14 to 16 is consistent with what we do with other lines that we draw distinctions about molestation and other offenses related to children. That's the only place in the code that it's not consistent, so we would submit that maybe that to 16 does make that consistent with the state.
Thank you. Mr. Sessler. Oh, I'm sorry, Mr. Coomer.
Wait.
No further questions. Thank you, Mr. Sackerson.
Thank you.
Let me call on Scott Key with the Georgia Association of Criminal Defense Lawyers.
Good morning.
Morning.
I come on behalf of GACDL to really speak to the appellate section of this. I'm the chair of our organization's amicus committee. I'm also the secretary of the appellate practice section of the State Bar, and I do not come on behalf of that section, although I will tell you there's been much discussion about this provision of the bill, and that in the bar, and particularly our section, may later have a position on this as official. But a couple of things to think about, particularly with respect to Section 5, which is lines 44 through 49. This provision of the bill would apply to any evidentiary ruling that excludes evidence. It could be a hearsay ruling. It could be anything that excludes evidence that the state seeks to admit. Right now, there is a procedure in place where either the prosecution or the defense can move for a certificate of immediate review. If the trial judge grants that certificate, the appellant would then petition for an interlocutory appeal to either the Court of Appeals or the Supreme Court, whichever the appropriate court would be. We have found that trial judges and both of the appellate courts do a fantastic job of using that process as a filter. And generally, trial judges will grant certificates of immediate review if the decision was close, if the judge thinks it would make a difference to the outcome of the case. And our appellate courts do a good job of filtering out the interlocutory applications that are most worthy. As this bill presently stands, all it takes is for the prosecutor to certify in the brief that it is not being taken for purposes of delay and that it is a material issue. The court, neither the trial court nor the appellate court, have any say in whether or not that is the case or not. That's not to impugn the honesty of any lawyer, but I can tell you that when you are an advocate, whether you are an advocate for the state or you're an advocate for the defendant, in the heat of battle, often you lose some sense of objectivity. I mean, the system sort of encourages that to some extent. And some of the things that the advocates think are material or think would not be taken for purposes of delay, the court ought to have a say in that. To give you a basis of comparison, in domestic cases that go to the Supreme Court on discretionary application, under their pilot project, the Supreme Court takes non-frivolous appeals, and we have to certify that it's a non-frivolous appeal. But the Supreme Court has the ability to say, counsel, I disagree with you. I think this is a frivolous appeal, and we're not going to accept your discretionary application. That is an essential part of docket management for the appellate courts. I fear that this bill, as it currently stands, would flood the appellate courts with appeals from prosecutors who disagree with evidentiary rulings. And there is nothing in this bill that gives the court, either the trial court or the appellate court, the ability to say, I disagree with you. I do think this is not material, and I do think that this is probably just going to delay things. To think about it further at the policy level, our appellate courts are really set up to deal with post-conviction cases. By that point, the record has been assembled. The court can assess whether or not an error was harmful or harmless. And even with the cross appeal, I fear that lots of issues will come before the court before the record's had a chance to be developed, before the court can know the meaning or the significance of an issue that's before it. I think the other part is that an appeal takes a long time to complete its course. If the Court of Appeals or Supreme Court, and our Court of Appeals, I've heard, is one of the busiest intermediate appellate courts in the nation. If the Court of Appeals has to take a case simply because the prosecutor has said, has certified that it's not frivolous and it's not taken for purposes of delay, you will find that many cases will be delayed during the life of that appeal. And of course, Mr. Chairman, you spoke earlier about that's why we have judges. That's why we don't have computers or software hearing these matters. I think while these appeals are proceeding in an interlocutory basis, I think the party that's going to suffer the most would be an indigent person who cannot afford to make a bond, because as that case is delayed, that person may languish in a county jail behind the wire and in the hard bed, as you mentioned earlier in this hearing, and while in the county jail at the expense of the county taxpayers. Beyond that, the longer, particularly in the molestation context, we've spoken earlier about the trauma of a victim having to come and testify. Delaying the process while an interim evidentiary issue gets appealed for perhaps a year while we wait for the transcript to be prepared and the record to be sent up also is going to potentially worsen the trauma of the victim who has to have that pending case going for longer than it already does. So I would ask the court to reconsider. I mean, I'm the court. I say that all the time. I would ask the commission. I would ask this committee to reconsider. I don't usually come here.
Just gave you just got a chill up my spine.
Yes.
And not a good one.
Sorry about that.
That's all right.
So I would ask you to take a look at that. I think it could have some unintended consequences. The other thing I would like to talk about briefly is this element of knowingly. I think, Representative Hightower, I think your questions are very good. As I was reading that provision of the bill, I thought about the FedEx guy or the UPS guy or the mailman. A common way that drugs are trafficked is that people will sometimes actually mail drugs over UPS or FedEx or the Postal Service. And technically, with the word knowingly in the first instance, technically the FedEx delivery guy who unknowingly delivers drugs within a package would be guilty of trafficking under that statute as it currently reads.
Thank you, Mr. Chairman. Quick question on the appellate rights, and I think I agree with you and Judge Lawton. That's your first name. I'm sorry, Judge. I forgot your last name. About that issue is part of the issue related to when you file your motion to suppress or a motion in limine pre-trial, and the judge rules close to the trial, that causes the problem delay of the jury trial, right? Because as it's written right now, you have to bring it before jeopardy attaches, which before the jury's impaneled. Question is part of the problem not getting not filing and disposing of motions to suppress. Does that relate to the lack of discovery you get in time from the prosecutor?
Well, Representative Pack, currently the requirement is that certain motions, particularly motions to suppress, have to be filed within 10 days of arraignment. And sometimes that can be a problem if you don't have your discovery yet. I think on a similar note, one problem that I could foresee, I think if this bill were to pass as written, as I think defense attorneys would likely start moving some of their motions to be heard after the jury's impaneled or in a bench trial because jeopardy is attached at that point. So I think tactically it might make a lot of sense for me to try to, or particularly a judge who doesn't want to be appealed under this new statute, to simply start hearing more evidentiary issues after the jury is impaneled, because then...
Well, if the judge doesn't want to be appealed, they just deny your motion then.
That's correct.
Then you will have no rights to appeal. So I'm not quite sure if that will happen when you're describing. I do agree with you. You might have some time limits on when you want to file your motion. But I could foresee a situation when you're filing a motion to eliminate, because before trial you should know what evidence you want to keep out. Could the solution be that you put a time period when you have to file a motion and it has to be ruled on before the judge, before the case is set for trial?
I think the reality of the way dockets work, though, is that we have a hard deadline that we have to file defense motions, and oftentimes just by the sheer number of cases on the docket, those can't get heard until as you're on the eve of trial. And then my understanding of the deadline to file a notice of intent to introduce similar transactions is that's 10 days before the trial. Mm-hmm. So that sometimes that creates a problem. Sometimes the evidence doesn't, or the witnesses, or even the knowledge of the similar transactions doesn't arise until you get later in the case and both sides are beginning to prepare for trial.
Okay.
Any further questions for Mr. Key? Seeing none, thank you for your testimony. We appreciate it. My sense is maybe that the conference call between the judges and the prosecutors maybe ought to be if you can figure out how to use the phone, a three-way conference call, or maybe even in a room over here, here in the building. That concludes our witness list. I think what we're going to do is we're off Monday, members of the committee. Our next regularly scheduled meeting is Wednesday. I can see us, depending on what other legislative traffic we have, I mean, the objective is to go ahead and to work out whatever issues I see potential issues on the Wilson piece. I see potential issues on the appeal piece. There have been some questions on the evidentiary hearsay issue. I wouldn't not necessarily characterize that as an issue, but there have been some questions. So on those three, to the extent that interested parties want to get together and drive consensus, that the committee would certainly appreciate that. That would help us keep the train on the tracks, and then we'll just march on from there. Anything else from members of the committee? Seeing none, I thank you for coming in on a Friday, and we're adjourned.